Good afternoon and welcome to session 2 of the Insurance Expert Showcase Series Lunch and Learn. This program is sponsored by the Torts, Insurance and Compensation Law section and co-sponsored by the Trial Lawyer section and the Dispute Resolution section of the New York State Bar Association. Today's complimentary informational program will run for 60 minutes and does not carry CLE credit. You'll be able to interact with the panelists at any time by using the Q&A function. Our panelists today are Lori Vahey, who is a managing member of a law offices in Rochester, New York. And Lori is a past chair of the executive committee of the Torts, Insurance and Compensation Law section and a past president of the Greater Rochester Association for Women Attorneys. I would also like to introduce national mediator Michelle Kern-Rappe, who sits on the executive committee of the New York State Bar Association's trial lawyer section, as well as the dispute resolution section. And without further ado, I'd like to pass the mic over to Michelle.
Thank you so much, Gina. And I need to say I am eternally grateful to Gina Bartoshevitz for all the work she does. And she makes my job very easy, just coming here and sitting myself down and having a wonderful conversation with Lori, who I am so delighted to continue our conversation, I'll say. We got started a little early today. She is an insurance expert, and as all of us who've been watching this program, I think we had over 60 attendees last time. There's been a lot of excitement about this particular issue and speaking to experts like Lori, because as many of us know, there's been a paradigm shift at the courthouse. When I started at the courthouse, most attorneys had that litigation mindset, and that litigation mindset was the way we would navigate our way through the courthouse, and it would guide when we would settle. With the encouragement of Dan White's, Lisa Courtney in the ADR division, I was encouraged to reconceptualize how we litigated in the courts in a much broader, more collaborative and problem-solving way. And I was asked to create the first mediation program in New York County, which I created the rules and ran for many years with the help of wonderful law students, one of which is still on working with me now, Rebecca Leibowitz Rothman. So I want to thank her for all the great things that she's doing. So I did that for quite a while. And what I've always said is that mediation really does recognize the brilliance and creativity inherent in the litigator, because we always ask so much more of the litigator to think in a more collaborative, broader way and a creative way beyond the litigation mindset. And I always have felt so grateful to have interacted with so many very brilliant and creative attorneys, including Lori here, which we're going to hear from in a couple of moments. Now, with the creation of Rule 160 that the court created, there's a further paradigm shift to mediating cases early on. And so I want to start the conversation in talking about some of the challenges when insurance plays a major role of how do we mediate a case that is starting so early on. So Lori, what's the right time for early mediation?
Well, thanks for asking, Michelle, and having me here today. And I just echo your comments about Gina and Rebecca. They've been fabulous to get us together for this program. And it's so true about the paradigm shift in terms of from litigation mindset to, an alternative dispute resolution mindset, and the litigator kind of just being open to that idea. So the right time for early mediation can almost always be at the beginning. So what's the right time? It's almost every case if you have everyone in agreement who would have to participate in the mediation, including their insurance companies, to have at least some basic disclosures prior to the mediation so everybody can come in with a comfort level. I've done plaintiff's personal injury cases, I've done defense personal injury cases, commercial litigation cases, And I've represented the insurance company, so I kind of come from, I'll say a global mindset. If I'm the plaintiff, I want to do early mediation because it's probably in the best interest of my client to have it done early. Not only do they get money, hopefully, it's because that's what you're seeking, but just peace of mind and having closure, being able to move on in their life. And then from a insurance company perspective, and I would think that in many cases, what I'm seeing is the insurance companies are becoming even more mindful of defense costs. That
Mm,
this may be something like recognize your exposure and see if you can end it in a timely manner early on by coming to the table with that mindset of maybe not scorched earth, but we recognize we have certain exposure. Maybe the plaintiff has some certain weaknesses in their case. We don't think this is going to get better with time in terms of the resolution of this matter. And so let's disclose some of our, our insurance information early and come to the table and see if it can get done. And then if it doesn't, then well, okay, that means we have to take this on a different trajectory. So to me, it's always a good time to think about mediation early in a case or even pre-suit.
pre-suit. So is that something that you come across too often? Pre-suit, learning about a case and before it gets commenced?
I'm finding more and more that we're seeing pre-suit mediations because the insurance carriers that we are dealing with are recognizing in certain circumstances, maybe it's a rear end motor vehicle accident case, and the plaintiff is a passenger in a vehicle. You know that and they have clear liability because there's a serious injury. Why aren't we talking about this early before we have to, spend money on defending, taking depositions and doing things when we really know what's already happening? A labor law 240 case where it's strict liability. If you can round up the right players and get people to agree, and I know we'll talk about it later, to who should contribute what, then it certainly makes sense to talk about it early on with the plaintiff, or even if it's limited insurance proceeds available, it's certainly the insurance company has to think about like, wow, I might be able to settle this now and reduce the exposure to my insured who I'm supposed to act in the best interest of my insured, and I'm the insurance company and I'm defending that. The best interest of that insured would be to get rid of this early because we're going to have to pay. And then that gets rid of it, that possibility for an excess judgment.
Well, I mean, this is great, and I love the way how you isolated two like almost clear instances in the PI case, the rear end case, and then in the strict liability case for construction cases. But we've had these cases forever, for eternity, for hundreds and years. And I'll say back in the 80s or 90s when we were practicing, the insurance company would come to the table virtually with nothing. So how do you see what do you see such a paradigm shift occurring? And yeah,
It's a fascinating issue, I think. And this is my personal opinion. So our firm tracks verdicts across New York State.
wow.
And whenever we can get our hands on that information, certainly ones that are reported, but through the goodness of those who participate in the New York State Bar Association, whether it be the tickle section or trial lawyers, we talk, we share information. And I personally I get the transcripts a lot of times of the trials, and we're seeing larger and larger verdicts. And so I
Okay.
think we have to be
I mean, like what
mindful.
they're calling the nuclear verdicts or those kind of, okay.
And just in general, we're seeing the possibility, doesn't mean it happens in every case. And oftentimes ones that go to trial, there's a reason they go to trial, right? Maybe they have more value and the insurance company was not offering what the plaintiff thought was appropriate. Or maybe the insured or the insurance company defendant thought like, hey, we really have a good defense here, so we're going to go to trial. So those may be the outliers. And I think
Yeah.
that's sometimes the question, but I think overall what we're seeing is an increase in value for cases in general. I think we're seeing an increase in verdicts in general. And I think what I'm
Yeah.
dealing with, and I know we were going to have a participant today who may also deal in this area, when you're consulting with businesses or individuals about the amount of insurance that they need, it's changing. So the world for a while thought like, oh, if I have $1 million commercial general liability policy, that may be enough.
That's right.
And my personal opinion is it's not enough these days. Depending on what you do, but I think in most cases it's not. So if you're finding a situation where the entity has, or a person only has $1 million and you have the potential for a much larger verdict, then you're going to see a situation where the insurance companies get actively involved, or the defendant insured with their insurance company to be like, we need to pay this out, get it done.
They're underinsured. Wow, that's really very like that is a very interesting trend, because I'm sure you remember it used to be thought of as a sign of weakness to come to the mediator, to come to the table and wanting to negotiate, on the side of the insurance company. They were just, no pay for, for quite some time. So that's very interesting paradigm shift that we're seeing in the past, we'll say, 30 years. And that leads to the next question. How do you prepare for a complex matter on the level of what you're talking about when there's virtually no discovery?
Yes, well, it's an excellent question. And if you're going to approach it in different ways depending on who you represent. So if you're the plaintiff's attorney in something, you need to be on, before you agree to mediation, you need to be talking with your defense counsel or whoever is that's going to be responsible for negotiating, and talking to them early on about, we will agree to go to mediation if, create certain terms. We will go if you agree to disclose the insurance, either limits or policies that would be available to, indemnify for this claim.
Could
And
you unpack that a little more? Because I know, so there are some people who aren't clear on the limits, policies, all of that. What does that mean to disclose the limits, policies?
sure, it's a great question. So typically when someone buys an insurance policy, they buy it for a certain amount of coverage. What the insurance company would pay, that's what we refer to as the limits. The top amount an insurance company will be responsible for under their insurance contract to pay for a claim. And so typically what we're dealing with are occurrence policies. So it's when the accident happened, what policy was in place, what's the top dollar amount that you bought in that contract that could pay out a potential claim. And so when we have different kinds of policies, you may, like if you, in New York, if you're driving a car, you have to have an automobile policy. It's mandatory. You can't be driving around your car without having an auto policy. It'd be a violation of law if you do. So there's minimum limits that you have to buy in New York State, and hopefully you talk to your insurance broker or agent about what those limits are that you would buy. What's the maximum amount? If I got into an accident, how much would my insurance company pay on my behalf? What limits would it pay? So there can be an occurrence limit, like for one time. Then there can be total limits that could happen during the course of a policy. And so that's the aggregate. So if you are reading what's referred to as a declarations page, so if you're plaintiff's counsel, you can ask defense counsel, like, hey, I'd like to see from the insurance broker, or get it, from either from the defendant, or they get it from their insurance broker, the declarations page for the policy. Well, what's the declarations page? It's the summary. It's the summary of how much insurance and the type of insurance that was bought. And so great if you can get the whole policy, but if that may be more challenging, you can usually always get what's referred to as the deck page, the declarations page. And so if you're a plaintiff's attorney and you're preparing, you don't want to come into a mediation without a full understanding of what insurance is potentially available to your client to resolve that claim. And so you're talking to them, and maybe if it's pre-suit, you're talking directly to the insurance claims representative. And New York law says that you can get the limits, it's under the insurance law regulations and statutes. You can ask how much insurance is available under an automobile policy, and they have to tell you within 30 days.
Wow, I bet a lot of people don't realize that you could do that.
Yeah, you send that letter really early, you send it to the insurance company, they have to get back to you. And then once you get
the
that,
different policies as well, I guess.
yes, and then you're gonna want to inquire first, because as you can imagine, there could be more than just an automobile policy. What if on the other side, the person bought a personal umbrella? So they bought themselves, this is like an insurance policy that walks around with you. It covers all kinds of claims. It may not just be limited to an automobile claim. It could be a slip and fall on your property. It could be all kinds of different exposures. So you want to be asking, is there any excess insurance? Anything above that policy that you're asking for? And I've kind of jumping ahead to resolution, if you decide to settle, if you say you have a bad case, but there's a limited amount of insurance, so you're like, okay, your client has agreed, you fully talked about it, the other side doesn't have any assets, we're gonna settle this early, pre-suit, and this is how much they've told us. My office recommends, and what we do is we ask the defendant, so that would be the potential defendant, or, if this is pre-suit, to sign a no excess insurance affidavit. We
Wow.
want them to swear to under oath that they don't have any more insurance. And just as a quick note, we did that when I was at my prior firm in one plaintiff's personal injury case. And before that affidavit was signed, we thought the case was going to be settled. Then all of a sudden we found out that the defendant had $1 million umbrella policy on top of the other insurance.
Oh, wow.
And it's more just because the auto claims professional didn't know.
Right.
Could be with a different carrier. They
That,
never really talked to the defendant about it, they're insured about it, until they presented them with the affidavit, and then they were like, oh, I have an umbrella policy. So, so it's just one of those things to be mindful of when you're preparing. When you're the defense, if you're the claims representative, maybe for that insurance company or your defense counsel, having that personal conversation with your client about what other insurance may exist. And so, we've had cases internally here where we're representing a defendant in motor vehicle accident. And when we meet and talk with that person initially, we ask that question, hey, do you have any other insurance? Do you have an umbrella policy? Ask those questions, and definitely ask those questions prior to mediation, and getting ready, because there may be other insurance policies and everybody's gonna have to be put on written notice. Super important, to write to each of these insurance companies and put them on notice and getting engaged, start conversations with the claims reps.
so that's really, and so in terms of the preparation, what in your experience is are the critical pieces or information that the insurance carrier needs, say pre-suit or early on, what do you know as an attorney that you have to get to that insurance carrier before they're going to give an offer to your client?
So, and it's a great question. So what does the insurance company need in order to be able to go and have like a meaningful mediation, right? And when are they going to come to the table and actually be able to resolve it? And it would be what the insurance defense counsel would normally put together, and that's a report, right? Everything has to be in writing with the insurance company, and they're gonna need the plaintiff's critical medicals. And so if you're plaintiff's counsel and if you're serious about getting a case resolved, then the defense counsel is likely gonna want you to disclose ahead of time all the medical information, including any pre-existing. If I'm defense counsel and I see pre-existing injuries, I'm gonna want that information before going to mediation, because it's a trust relationship, right? Even though
Exactly.
you're opposing sides, you gotta trust each other that the information that you have is true and accurate, and that it's complete enough, right, to be able to do that. And so they're gonna analyze the liability. Do you have enough information about how the accident happened? Do you have, and giving them the documentation? If you're talking to your insurance company, you're gonna want to, this motor vehicle accident, get that police report. Talk to your insured, talk to the defendant. If you can, they'll let you talk to the plaintiffs, who's the attorney, as to what their claim's gonna be. And get the medical records if you can, and summarize them and talk about if there's pre-existing or not. Look at the age of the person, talk to plaintiff's counsel about, well, what are they thinking the damages are in this case? Are there future damages, or is it something that's, limited? So we've had a case here in the office where motor vehicle accident, passenger in a vehicle, 3 broken ribs, and really treatment was done. Okay, there's a pretty finite value. We're gonna lose on liability. And so we're gonna set a fair value on this. And doesn't mean that the parties are gonna agree, but hopefully with the mediator's assistance, they're gonna, on that type of situation, they're gonna be able to reach a number. And it's a good time to mediate that.
That sounds, oh wow, that sounds great. Now, have you been in mediations where the various insurers are having their own private mediation or debate in the midst of a mediation? And What's an example of something like that has happened?
Yeah, so this is a real common occurrence in my world. I can't speak for everybody, but oftentimes what you can have, particularly in the construction context, where you may have many contractors, you have an owner, a general contractor, subcontractors, who all have potentially different insurance, or they're looking, typically, there's contracts, and they're looking to one of the parties, defendants, to pay. And so what can happen is you get to a mediation and all of a sudden, in a construction context, the owner's looking at the general contractor, and the general contractor is looking to the subcontractor. And then the subcontractor's insurance is like, well, I want you all to contribute. And they're all like, no, you're gonna pay. And you can spend a good time of, a good portion of your mediation just fighting amongst the defendants in order to make, in their insurance companies, to make an offer. And oftentimes what I see is initially with these mediations, sometimes no offer is ever made to the plaintiff because they just can't get to the point of agreement during the course of the mediation. And it could be because they didn't talk about it ahead of time. It could be because there needs to be a little bit more discovery in order to understand what the exposure is for each of the entities that's being looked at. It could also be that the one entity who's going to pay has multiple policies. They may have an auto policy, they may have a commercial general liability policy, they may have excess policies, and you just haven't figured out who pays in what order. So for those kinds of situations, it's really important for the plaintiff to have an understanding of who are all the insurance companies involved, like who are all the defendants, who are all their insurance companies, and asking the questions of counsel before you get to mediation of, do you have an understanding as to how an offer would be made? They're not going to probably tell you before mediation, but do you have an understanding? And then making sure, like, well, I'll agree to go to mediation if you're the plaintiff. If I want disclosed ahead of time to, and maybe it's just to the mediator, the insurance person who's going to be in attendance, hopefully not just by telephone, because oftentimes then you're chasing someone. Who's going to be the person in attendance? What is their email address and what is their telephone number? And that has to be disclosed at least a week before the mediation. Because you need those key players involved from the insurance company. And if there's multiple policies on behalf of an insured, it's on the insurance companies themselves, but with the prompting of defense counsel, if they think this case should go to mediation, to get from the insurance company representatives, okay, who's paying what? How are we making it? And doing it well before the mediation. And that really takes a long runway of time. So I would suggest to people in those instances, I'll give an example. So we have a case in the office that involves Super Creative on the defendant's side. They're a large company, they have in-house counsel. It involves a commercial vehicle that dumps waste. And so they have an commercial automobile policy, and someone got injured while there was being waste emptied from this vehicle. But it actually happened after the waste was completed and something else had happened. So not only was the commercial auto liability policy triggered, there was multiple layers of excess for that commercial auto, but then they also have a commercial general liability policy. And because of the allegations in the complaint by the plaintiffs, and if you're a savvy plaintiff's attorney and you make allegations that can trigger multiple policies when you're drafting that complaint, you're certainly doing a great service for your client. In terms of, there was specific allegations that it wasn't just the unloading and loading of this commercial automobile that was negligent, but other things that had been done that had nothing to do with the vehicle. And so it triggered that commercial general liability policy.
Oh, wow.
Yeah, and then so the carriers for the auto and the commercial general liability policy reached an agreement as to the percentages that they would pay for the defense.
And this happened, did this happen before the mediation or during?
Yeah, so that happened, the defense agreement was before the mediation, but then they went to the mediation and the plaintiff had made a very large demand in excess of all the insurance policies, because there was multiple layers of excess insurance above the commercial policy, general liability policy, and also one's excess specific to the auto policy.
And this was not known before the mediation of that demand.
Yeah, yes. And so that's what happens sometimes when you have that big demand made at the mediation, all of a sudden you're like, whoa, this triggers these excess policies. We got to put them on notice. So if a plaintiff had maybe made that demand ahead of time, then it would have been super helpful because now that you're involving a lot more people and companies who want information, they all got to document their file. And then you had the insurance companies saying like, well, no, even though we agreed to a certain percentage for defense, the auto should pay everything first. So during the course of the first mediation, there was no offer made to the plaintiff
Wow.
because they just were fighting. And then the excess carriers, they're trying to get them on the telephone during the course of the mediation, but there's no way you're going to get a meaningful offer from an excess carrier who has no information at that point. And so there's going to be
So
a
that
second.
sounds like it was a failure on a couple of levels because the plaintiffs didn't apprise the other side of the demand so they could prepare the various excess levels beforehand. And then it sounds like maybe there should have been some kind of level of defense-oriented mediation before to
Yeah.
get clarity on the participation. Very
Yeah. So
interesting.
Yeah, so what ends up happening in this one, it's still ongoing, so can't talk about it in too much detail in terms of
Yeah.
party names, but, and it's a typical scenario though,
Yeah.
is then you're talking about defense counsel saying, you guys need to get coverage counsel, right? I'm here to defend the insured. The
Oh,
insurance companies, you need to get coverage counsel, and now we're engaged in this one as coverage counsel, and now we are having those active negotiations to get ready for the next mediation.
so
And
could we unpack that for a minute? What is coverage counsel, the difference between the defense counsel and coverage counsel? And yeah, so what would your role be in terms of that?
Yeah, no, it's a great question. So there's often sometimes something referred to as the tripartite relationship, right? So in a tripartite relationship, there's the client. That's probably the defendant, the main action. That's the one who's been sued, who's named in the lawsuit as a defendant, whose employee in this instance was the alleged wrongdoer, right? So that's the defendant. The insurance company is actually, what they do is they appoint an attorney to defend their insured, the defendant. That attorney has the obligation and is only representing the client, the named defendant. The insurance company is not their client. And they can't advise the insurance company on coverage issues, like whether the insurance company has an obligation under their policy to pay first or pay second or pay third, because their obligation is to get the case done within coverage so that their client doesn't have to hopefully pay any. And so it really doesn't matter to defense counsel. And they don't want to give guidance to the insurance company in that. They just they want all the insurance companies to pay, or if their client says, hey, it's better to pay under the commercial general liability, maybe they'll focus a little more there. But when you are in this case, coverage counsel, you're directly hired by the insurance company to represent the insurance company's interests and to advise it on its obligations as you see them and with the information available under the insurance policy. Because the insurance company has its own potential liability, right? So if the insurance company doesn't act in the best interest of its insured, it acts for itself. Like, I don't care if this thing settles. I'm not going to go to mediation. I'm not going to figure out who has to pay what. Just let it go to trial. And then there's this huge verdict that
Mm.
leaves the insured exposed. The insured's going to turn around and be like, hey, you had an obligation of good faith, fair dealing under this contract of insurance. You had an ability to settle this thing within the insurance limits. You were more worried about this other insurance company paying than you put your interest in front of mine. Now you got to pay for that extra, even though I didn't buy that much insurance, you still got to pay for everything because you did that. That's wrong. You're wrong. So when you're coverage counsel, you got to take that into serious consideration. Like, okay, we're here to do what's best for the insured, but what does that mean, this policy? Because it's a contract and you only have to do what you're obligated to under the contract. You're not, if you buy a $1 million policy as the insured, they come and they buy a $1 million policy. It may be in the best interest of the insured to pay $10 million to resolve the claim, but by contract, they only paid premiums of 1 million. So maybe you're telling them, hey, I think you should offer at least a check for $1 million to see if you can settle this. And to cover you, the insurance company. So the insurance coverage counsel is thinking about, okay, what's best for the insurance company to get this case resolved? What are their obligations, and giving guidance to the insurance company as to what it should do. So you're really playing very different roles. I think that's kind of the fun of it. Sometimes it's fun to be defense counsel, then you're trying to set the insurance company up. I'm gonna set you up for bad faith, and that's gonna put pressure on the insurance company. And bad faith means you didn't act like you were supposed to in good faith. So you're gonna be responsible for anything extra a jury could find, guest could find. And you start documenting that in a very specific way. And oftentimes that will be pre-mediation. So
What's an example of bad faith?
yeah, so say you were talking about, and it's true, so, and if anybody from State Farm here, I apologize, but in our area, there used to be a reputation that State Farm would not settle cases. They tried everything. And they did that for business purposes. They were trying to have plaintiffs' attorneys not want to take a personal injury case if State Farm was going to be on the insurance company on the other side, because they knew it was going to be a lot of work. They knew it was going to cost a lot. It was a small value claim. They weren't going to pay on it. They were going to make them go all the way to verdict. And so in that instance, and this is, and I'm just making up something. So say State Farm's like, we're in a no pay position, but it's a rear end accident. And it's a, 25,000 minimum policy under New York. And the person suffered a fractured spine that required surgery, and they've been out of book ever since. And so clearly it's a rear end accident, negligence is there. So
Liability,
yeah, say the plaintiff has no.
Damages.
Yes, and then damages, but they're just trying to see if the plaintiff will just take next to nothing, and so they don't settle it. And so they go to trial. And they get a big verdict. They get a $5 million verdict, and there's only 25,000 in insurance. Now, did they do the right thing by the insured? Did they act in the best interest of the insured? If the plaintiff had agreed to take the policy limits at any point prior to that verdict, and State Farm was like, no, we want to roll the dice, and we want to gamble it, and they lose, then that defendant, who can also assign it to the plaintiff, but that defendant probably has a pretty good bad faith claim against that insurance company. It's documented that the plaintiff was willing to accept the policy limits. They would have gotten a general release. They never would have had a big verdict. The negligence was clear, liability was clear, damages were clear in excess of the policy limit, and they made the insurance company made a business decision in its best interest as opposed to the insurance best interest. And so they're going to seek extra contractual damage. I know my limit was only 25,000 that I paid the insurance company for, but they did this to me. They appointed a counsel, took it to trial, and the insurance company would never offer its $25,000 limit when it could have to settle it. That's bad faith. I will
See,
say
that case needed you as the coverage counsel.
I will say it's an interesting thing. Bad faith. There hasn't been a bad faith decision in favor of an insured, or if it's been assigned to a plaintiff's attorney in, I think, over 100 years in New York. And so people are like, oh, bad faith really has no teeth, but that's not true. I
Mm.
think the reason we haven't seen a bad faith verdict or finding against an insurance company is because when that gets brought to the insurance company's attention, either by plaintiff saying you're acting in bad faith by not doing this for your insured, or the defendant, when they get their own referred to as personal counsel, when they get their own
Right.
defense counsel or personal counsel saying, hey, you're acting in bad faith by not doing this, it takes it to a whole nother level within the insurance company. And then it triggers another layer of insurance. And that's the E&O, errors and omissions policy of the insurance company.
Huh.
Because they buy themselves insurance for potential bad faith claims.
Wow.
So there's all these things that happen behind the scenes when someone's alleging bad faith. In the proper case. I mean, if someone comes out of the box, it's like, oh, it's bad faith, and and you haven't documented the file and those kinds of things, it's probably not going to get a lot of attention. But it's likely to get attention in a serious case where there's been maybe some mishaps in terms of, like that mediation I was talking about earlier, where the insurance companies spend the whole mediation fighting between themselves as opposed to making an offer. They could, the main insurance carrier at any time could do something what's called pay and chase.
So when
They
you
could,
say the main insurance Carrie, would that be like the subcontractor you were saying, or which one would, is typically the main, in the way, this is an interesting subject, identifying policies and how they interact. Let's just limit it to, say, in a construction case. What's the typical way that you've seen a roadmap, if you will, between the GC and the owner and the other, subcontractors?
Yeah, that's a great question. So you have the owner at the top of the chain, typically the GC, and then the subcontractor, and they typically have contracts that we say it flows down. The payment, the liability flows down. It goes from the owner all the way down to the subcontractor.
Mm-hmm.
And so typically the owner is looking at the subcontractor or the GC to pay. But maybe they're saying, well, the owner, you had your own liability. You did something wrong independent of us, so we don't pay. And maybe that owners, like, they want this case done for whatever reason, and I'll just make up something. Although we do have a case where this happened. So there was a case where it was a plaintiff's 240, labor law 240, which is strict liability. Liability had been found. And the owner felt very, very confident that they were going to ultimately be able to get contractual indemnification and insurance coverage from their contractor, the GC as well as the subcontractor. So they said, you know what? Plaintiff is offering us a sweet deal. We are settling this case. We are the commercial general liability policy for the owner. And while we don't believe that we ultimately should be the responsible paying party, we're going to pay. We're going to pay the plaintiff. We're going to get a general release, and then we're going to chase. We're going to go after the other parties that we believe really should be responsible for this. It's called a pay and chase.
Pay and chase.
Pay and chase. So it happens a lot in the construction context.
What's the reasoning behind paying like quicker and then chasing? As
It
opposed to
usually,
waiting it out?
yeah, usually because in a 240 situation or wherever a liability has been found, 9% interest starts to run.
Okay.
And so you start having this concern that if you don't have the other insurance companies coming to the table, the amount that's going to be owed is just going to be higher. And there's a judgment now. So there's a judgment. So say in this context, with the construction and the owner, the plaintiff is successful at proving labor law 240 Brent 1 liability, which is strict liability. So someone fell from a height or something fell on them. There's a judgment against that entity for labor law 240. And the plaintiff is going to be like, okay, I'm going to trial. I've got a judgment against you on liability. I got 9% interest running, and I'm going to get a big judgment against your named insured, your company. And if they're going to go try and get, financing for the business or they're going to have this big judgment against them.
That's it.
And so the business is like, oh, we can't have this judgment against us. It's going to screw up our business. Like insurance company, I don't care if you think you can get it from somebody else. I need you to settle this thing. The plaintiff is saying they'll settle it. If you think somebody else will ultimately pay you back, do that. Pay it and chase. And so in this instance, that happened. The plaintiff was willing to settle for a lower amount than they thought the case was worth, essentially in
Because
verdict.
of getting
Yeah.
that money sooner.
Yes, they didn't want to have an actual money judgment against the company. They had started with the other insurance companies, what we refer to as the third party actions, they had started those late. So they
Oh,
didn't get those other insurance companies involved early.
right.
It's so they're like, well, you just third partied us in. This is, in terms of the GC and then the lower subcontractor, you waited too long. That's why identifying insurance early, great, I mean, essential for mediation, but essential ultimately in resolving the case. And it can be that you're at a mediation, you didn't get the other insurance companies involved. It doesn't mean that those rights go away. But it might mean that insurance company who's getting pressure from the insured to settle this thing because they don't want a judgment against them is going to say, you pay it. I'm the owner, you're my insurance company. I've got a liability finding against me. I don't want a monetary judgment. You pay it, you go chase those other insurance companies to get paid back. Not the optimal place to be.
Right.
Not the optimal place to be, but it happens. And then you have an
So
insurance fight.
wouldn't that be, say the owner wanting, could bring an action, quicker against the other because they don't want to be in the position of pay and chase if like not all the right people were brought in right away or the insurance understood right away, but that owner. So who would like have who would the impetus be on? Is it the plaintiff, of course, but then maybe also an owner, attorney as well, defense attorney.
Oftentimes, yeah, it makes a difference who the onus is on the value, on the size of the value of the case. So in that instance, so the plaintiff sued just the owner.
Mhm.
And so all they cared about was that the owner, it was a very big company. They had tons of assets and they actually had a lot of insurance. And it was
Right,
going to be enough insurance coverage. So the plaintiff was like, not my problem.
right.
When they get to mediation, they don't care. They just pay me. And then in that instance, it really oftentimes is the owner or their insurance company. So you'll often see when you're coverage counsel, if they get you involved early, or even as defense counsel, we keep it internal in our office, and it's great for mediations. It's a tender chart. So
Mm,
tender being
that's great.
when you write to someone to say, we believe you or your insurance company is ultimately responsible, not my client, whether that be the insurance company or whether that be the defendant. And we keep track of like everybody, every potential insurance policy that could exist, everybody that we wrote to for that, the responses that we get. And then when we go to mediation or ahead of time, we're thinking about everybody that has to be put on, everybody that has to be there in order to have a proper mediation. And then a lot of times you're talking before the mediation, we've got to get an agreement together with these other insurance companies or defendants as to how we're going to offer money to the plaintiff. And so I was
Right.
in a
Boy, a
pain.
tender chart. After 35 years of mediating, I never received one in construction. I'm going to say the Lori Behe tender chart. Okay. That's a
It's super
great
helpful.
idea for a
I
mediator.
love charts. I love
Me
summaries. I love
too.
charts. And
Me
when for the mediator, I usually give them the chart of who the players are, the
Wow.
tender, the policy limits, and what we think, right? Because if you're the first one out of the box in a mediation as to this is how everybody should pay, then you're
Right.
probably coming in with a leg up. And the mediator wants to know quickly. Like
Oh,
if they
yeah.
want to, yeah, if they want to be effective, which good mediators, of course, want to be effective. They want to have a good track record, but they're only good sometimes as the information you give them and
Absolutely.
what you give them early. And one of the things I know we were talking about prior to today is for the mediator, when you're giving that information, I love confidential submissions prior to a mediation. So you can be
Right.
as frank as possible.
Interesting.
Yeah,
I do
these
too.
are, yes. And then, and maybe you have two, maybe there's one, because maybe the plaintiff wants to like, no, we want to share. Oh, or you have one that's generally submitted, and I know some mediators that will say, but you can send me a separate email
Yes.
that's confidential.
Mm-hmm.
Super helpful, super helpful. And I think I love if we can have an ex parte conversation with a mediator ahead of time after the submissions have been in. So the
Mm-hmm.
deadline is passed for submitting everything. And you've talked to your client about what you think some of the issues are, which may include insurance coverage issues. And so they're prepared because a lot of times media wants to talk directly to your client. They need to know like what the issues are. And then,
Exactly.
yeah, and then finding out from the mediator if everybody's agreed ahead of time, like what does the other side really see as the sticking issue, particularly if it's an insurance coverage issue? Because you want to have that resolved before you go into the main mediation, if you can. So
Absolutely.
here we had a case where I went to downstate to mediate the case. It was a pay and chase. So the insurance company had paid to resolve a labor law 240, as we similar to what we talked about earlier. And we were now chasing some other defendants to pay us back. And so now it really became, we were talking a lot about coverages and those kinds of things. And another entity had paid with us, kind of a wacky set of facts, but so
Hmm.
my client insurance company had paid, another insurance company on behalf of another entity had paid the plaintiff who was injured to solve the case. We started chasing these other two. So now we're going to mediation. So we needed to talk ahead of time. Okay, if they make us an offer, how are we splitting this off? So we had an agreement. So, okay, my client gets X percentage, your client gets X percentage. So doing that before the mediation is super important. And we needed to agree on what the demand was. What was the demand? Like we need to agree on the specific dollar. And we needed to have our insurance claims professionals at the mediation for the entirety of the mediation.
Did you have that separate meeting with the mediator to discuss these variables, or did you do it just directly with the
So
other?
this one, we actually were able to reach an agreement directly. But
Okay,
I have in other instances had almost like a mediation where
exactly.
they get everybody involved and you get all the players involved and you agree to mediate and see if you can reach a resolution. And if you can't reach a resolution, maybe you reach some other really creative idea. And that could be like a high-low arbitration. Maybe you say, we're gonna pay and chase. I think I should really be the one getting 60% and you should get 40%. Well, maybe you take that coverage dispute, because maybe it's a priority of coverage or whatever it is, who should get more? Let's arbitrate that. Like,
Do you want to
let's
just
do this.
briefly just explain what a priority of coverage issue is?
Yeah, that's great. Great question. So, and I apologize, sometimes I forget that's the lingo. So priority of coverage is when you look at all the insurance company policies that might have to pay for something, who pays in what order under the language of the contracts and the law. So if you remember that one case where I talked about like the garbage truck, and it
Yeah,
had an auto policy with excess policies, but I call them tranches, and then you had a commercial general liability policy with excess policies. You had these like two separate lanes or tranches of kinds of policies. Now you got to determine, well, which one's going to pay first? Is the auto paying first? Is the commercial general liability? Priority is determining who pays in what order for each of these policies. And that really comes down to, sometimes it's a factual issue that might make a difference. But oftentimes it comes down to what do the insurance policies actually say? Because there's provisions in the policy that typically deal with in what order they pay. And that's the priority order. So I
is
also
that
have a,
also up, could that also be part of the pre-mediation that you're talking about?
absolutely, and I think it's important for, if you're on the defense side who has all those insurance companies involved and your defense counsels, you're not advising the insurance companies, but you're looking to those insurance companies to get their money together and make an offer to the plaintiff so you can get this done for your client. You need to be engaging them early. Like you need to be asking them, like, what do you need from me? Like it's defense counsel. Maybe they need an analysis of the damages in the case. Because a lot of times an excess or an umbrella policy, someone who thinks they come later, they won't even really look at a case prior to mediation if they don't think that they're gonna be triggered. Like, well, you're never, I'm fifth in line and, and you only get above 50 million if, I'm just making up numbers here before you get to me. So I have a million cases on my plate. I'm not even looking at you. And then all of a sudden you're in a mediation where someone's made that $55 million and then you're trying to get on the telephone. So during the course of the mediation, you want to do that early. If you can have, and if there's a dispute, if you figure out early, so say your defense counsel, you're writing to all the insurance companies and they're saying like, I don't pay until I'm fit. Then you got another one who says, no, I'm fit. He's fourth, that insurance company is fourth and she's third. Then you want to get all of them together in communication, and that can often be effective with the mediator if she or he is able to and open to having those conversations before the main mediation.
That seems essential to me in the kinds of cases that you work on, Lori, and it sounds like you've been a real trailblazer in pre-mediation negotiations amongst the insurance companies. I think it's a wonderful way for us to work within the new framework and the paradigm shift of early mediation of these insurance cases.
It's
Quite incredible. Could I ask you just another quick question? In terms of the region, do you see, because it sounds like you're downstate, your practice is upstate as well. Are there any differences that you notice in your practice when downstate versus the upstate practice?
it's an interesting question. I will say there are certainly differences with how the judges conduct like the courtroom, the chambers, those kinds of things when you're in formal litigation, which can include insurance coverage. But in the mediation context, I think there isn't really much difference in terms of how mediations are conducted. sometimes I think it's, if you have, what I'll say, an upstate case, so maybe the case is venued in Erie County, right? Sometimes I think it's better to get a mediator who's maybe not from that area. Maybe they're from downstate, who has a truly outside objective, doesn't know the attorneys who are going to be involved in this, is not familiar with the judge who's involved, and so that trust can be built during the course of the mediation, and you're not second guessing, well, of course, Joe knows Ed, like Joe the mediator knows Ed, so he's good. And maybe Joe's mediator's not doing it. But there can be that perception, right? Perception is reality. And in
Yes.
mediation, it's so important that your client feels heard and that they can trust in the mediator, that without concern of like, well, they all know each other, or there's some kind of other concern. So I don't see a difference in terms of how the mediations necessarily are conducted. I think it's so mediator specific, but I am definitely becoming more of the mindset that in certain circumstances, that I think it's better to try and get a mediator from outside the area who's just got a totally fresh perspective without knowing the personalities.
Very interesting. I like that. And now we come to one of our favorite parts of the program. We're going to ask for any questions from our very captive and interested audience. And I think I see one. So let me, okay. Um, let's see. That's not a question. Let's see. I don't see any questions right now. So maybe we could continue. I want to for a litigator, I'll say, what do you think are important characteristics of a litigator who is asked to be in a mediation? So maybe someone who you'd want to be collaborating with in the mediation.
Yeah, so that's a interesting question. I think it's developed for me over the years and the decades that I've been doing this. And so first I'll mention, yeah, if anybody has questions, look like one just came in, we'll look at that in a second. Please ask. I do, to me, so I'm a litigator at heart, right? I think for me, mediation and negotiations has been the area where I've tried to really focus and develop my skills the most, because it doesn't necessarily come natural to me. I like to fight. I like to win. Um, but you can win in a mediation, and becoming more open to that mindset. And really, so for a litigator, you're looking for someone who's got that creativity, who's going to stick with it despite the other side maybe coming forward with a position that you think is absurd, and trying to come back with something, super creative, and or even just patience. So sometimes the litigator, you can get so tied to your defense positions that it can be challenging to let that go during the course of a mediation to see if you can get the case resolved. And so I've kind of learned that sometimes you got to understand what your end goal is first. So have a litigator who understands what's the end goal. If the end goal is really to get this case resolved at a certain amount, maybe you're just like, this is what the insured, your client wants, this is what the carrier is willing to do, really have a good understanding and really spending time well in advance of the mediation, getting prepared for it and having difficult conversations. But coming to the table with an open mindset. So recent mediation, we made a multi-million-dollar demand. We were just pay and chase that I was just talking about a little while ago. And they came forward immediately with a bracket. And what a bracket is, which is unusual, but now we're dealing with insurance companies fighting over money. So a little different. And they came forward with a pretty low bracket. They said, okay, well, we'll settle this case if you're, $350 to $650. We've asked for millions. And they're
Right.
instantly trying to bring it down to this low amount, which
Yeah.
we could have just been like, we're done. This is it.
Yeah.
But instead be like, okay, well, I take that bracket, the 350 to 650, and I take that high number, I consider that to be your offer.
Mm.
And so we came back like, okay, you have a $650,000 offer. And we gave the talking points to the mediator. Tell them that we consider this bracket, the top number, to be your offer. And based upon that, we'll reduce
Great.
our demand. And so you don't give up.
Exactly. That's a
Don't,
creative solution.
yeah, don't get
Yeah, that's
insulted.
tenacity. So that's terrific. Let's see if we have another question. Okay. How do you handle when there is a coverage question or reservation of rights when it comes to defense obligations?
Alan, that's a great question. So Alan Sachs asked that question. So your defense counsel is the question, and there's a coverage issue. A reservation of rights is when an insurance company has issued a letter saying, we may not pay for the ultimate judgment at the end of the day. We're going to defend the case, but we're leaving open whether we ultimately pay for a settlement. So in my opinion, right, that's that tripartite relationship that we were talking about. You remember, my obligation is to my client, the insured, the defendant in this action. I'm actually adverse to the insurance company at this point because I want them to pay. And just accept it. They know that. They know your ethical obligations, the insurance company. What we do is we typically report to the insurance company when we're doing our regular reporting. We understand, I think you have an obligation to find out if there's a reservation of rights or a partial disclaimer, which is they've disclaimed on certain kinds of claims. Because you don't want to make a motion for summary judgment to get rid of a negligence claim if it's the only one that's going to be covered, the claim, right? So you got to know. You want to engage with, and we report to the insurance company ahead of time and we say, we know there's this issue. One, ethical rules say you cannot disclose to the insurance company anything that would take them out of coverage. So say there's a deposition, you think there's testimony that's going to take your insurer, your client out of coverage. You can't tell the insurance company. They could go get a copy of the transcript on their own, but you're not going to put that in the report to the insurance. They're going to have to, and you're going to advise them, tell them, I can't advise you on the coverage issues. Just people, it's, they may be like hemming and hawing, or they may ask you to give a coverage opinion and you just have to say, I can't, to the extent you can't. You can't look at the policy and tell the insurance company what their rights are, particularly if it could just be a disclaimer or not paying on behalf of your
That's
client
fascinating.
if you're the defendant.
It's,
So
I think we're all learning how important it is to really understand and identify the relevant policies and understand what they all say and how they interact. We have another great question from Lorraine Mandel. What is a technique to break an impasse if all insurers wish to settle except for an insurer in a higher excess layer who may think the excess layer may not be triggered?
great question. Another great question. So Lorraine is asking this question, and it happens on a regular basis when you're dealing with any kind of catastrophic injuries or where you have the liabilities already been established in these big divisions. So if you think about the practical aspects of it, so say you have the main policies, maybe there's some excess above that, but you have someone who's back, like, they don't pay until there's $40,000 in the other, or $40 million in the other policy that paid. They don't have to pay for the defense, right? They're not paying defense costs. So they don't care. Like, you got to take it to verdict. So what you have to do is when there's an impasse, you have to start documenting with that excess layer. If you can get the main, whether it's a commercial general liability, auto liability, whatever it is, to say, we are going to tender our limits. You start getting each layer to acknowledge that the case, you got to document with a damages report. This case has a verdict in excess of whatever the dollar amount is to get into that excess layer. This is confidential reporting. So this is confidential reporting from defense counsel or other coverage counsel to the insurance companies. This case has a verdict that's going to get into that excess layer, but you got to document. And you have to other verdicts that have come out, why this case is going to establish it. I mean, be very specific. Put a demand out there that puts it into that excess layer. So the plaintiff has demanded maybe it's $60 million and you have to pay above 50 million to 75. We are in your layer. There's a demand in your layer. We also have a potential verdict that is in excess. You got to document all this. It's really hard because sometimes you just don't know, right? It's a subjective, it's the value of a claim. But then you also have like where an insurance company, not everybody's going to want to officially tender, the tender being officially say they're going to give their policy limits to somebody else. But excuse me, if you have a situation where you do have those underlying policies saying they will offer it, you get them to put it in writing, or if they verbally told you, you follow up in confidentially, insurance company only, defense chain, either by letter or by email saying everybody has said they're going to pay except for you. And so this is leaving the insured potentially exposed. And it leads to uncomfortable conversations sometimes, but it definitely needs to happen And hopefully it'll happen before the mediation with the plaintiff actually takes place so that you can get to that excess layer, and definitely make sure that excess layer has all the information it needs. So that it can't be like, oh, I asked you for this MRI and you didn't get it to me. Oh, I asked you for this and you didn't get it to me, because they're gonna try and document on their end that they didn't have everything so they could make a decision.
That's true.
Button it up, and then call the person, button it up.
You know
call
what?
them.
Lori, this is wonderful. It looks like we're almost at the end. We're definitely going to invite you back in the fall for just a defense only a mediation within a mediation, and we're going to have break that down a little bit more. But I want to thank you so much, Lori Vehi. I think on behalf of everybody, what a wonderful job. So thank you.
Well,
And
it's been
my
great, and every,
co-chairs,
yes,
Maria
and thank you to
Pagan
everybody who's been there.
and Margie Echeverria.
And if anybody has questions, they can always email me directly at the firm. Happy to answer them. And Michelle, it's been great as always. You're just the most amazing mediator and moderator for programs like this. Thank you.
Thank you. What a pleasure. And yes, see us next time for Danielle Visconti. It's going to be wonderful. Thank you.
Michelle and Lori, as always, thank you so much for taking the time out of your busy schedules to present this fantastic program today to all attendees. We would like to thank you for joining us today, and we'd like to invite you to join us to our third and final Lunch and Learn session on May 9th. I would also like to ask that you kindly complete the evaluation form for this program, which is located in your learning dashboard. Instructions on accessing your learning dashboard can be found in the information email that you received yesterday or earlier today. Once again, thanks everyone for attending today, and thank you for choosing New York State Bar Association programs. Have a great rest of your day, all.
Here.
Thank you again.